Okay, welcome everybody. Right before we started recording, we were just welcoming our new colleagues from Willamette University, new Dean Brian Galini and Jeff Dobbins, who has a long history with the Law Commission. Welcome to both of you. We're very glad to have you. Today's meeting is going to be relatively short. We're here to discuss one thing, and we'll have a more detailed meeting later in the summer. So I'm just going to have Sandy do the roll call, and then we'll move directly to discussion of our item on the agenda today.
All right, great. Let me make sure my mute's on. It is. So I'll just start at the beginning. Chair Runkles Pearson is here. Vice Chair Keith Benovich.
Present.
Thank you. Judge Bouchon.
Yes, I'm here.
Yep, thank you. Mark Comstock.
Here.
John DiLorenzo, is John there? I don't believe so. Justice Duncan, I wasn't sure if she was going to be able to come. No, okay. Next is Judge Egan, I don't believe so. Krista Obold-Eshelman.
Yes, here.
Thank you. And then from Willamette, we have Brian and Jeff Dobbins. I saw both here.
Here. And here, Jeff.
Thank you. Susan Gary.
Here.
John Perry.
Here.
Thank you. Cesar Brzezinski, I knew was not going to be able to attend. And then we have Aaron Knott.
Here on behalf of the Attorney General.
Thank you. And let me make sure. Jennifer Williamson, I don't believe is here. So let's see, make sure. Yep, so PK, we definitely have quorum and we're able to have our meeting.
Awesome, that's great. So since the time of our last meeting, just to give you a quick update, our probate modernization work group has undertaken a new task, which is looking at issues of remote attestation of documents. As most of you will recall, we already have a excellent work group on remote notarization of documents. And Professor Gary brought up the fact that remote attestation would probably also be a concern during this time of COVID. And the probate modernization folks have gotten right on that. Many thanks to them. And we did give, they did give, both of those work groups, gave a very nice presentation to the Senate Judiciary Committee this week in hopes that we can get both of those items in the working bill for a special session. I think it's my understanding that the remote notarization piece is already in the bill and they are thinking about remote attestation. But for today, we're hoping to get, I think, sign off from this group of commissioners on a draft bill for remote attestation, if indeed the legislature is going to be willing to take that up. So before I move to remote attestation, Mark, since you're the chair of remote notarization, do you have anything to add about our activities this week?
No, I think you hit it. We had a presentation and a demo, and I think it went well. So they know about it.
This was the first time I had seen the demo, and I thought it was great.
Good, good. Thanks.
So then on remote attestation, are we going to have Professor Gary or Mr. Curley?
I think Lane and Susan.
It's all yours.
Lane, I think you're on mute.
No, I'm not. Yeah, thanks. I'll start, and then I see we also have Lorianne Sills with us, who is our estimable drafter from Legislative Council. So I'll thank her for her work on this. Professor Gary wrote the report. I'll just give a few introductory remarks and then entertain questions or ask Susan or Lorianne if they have any more that they want to add. For the record, first of all, Lane Shetterly, proud to be your probate modernization, probate reform work group chair. And thank you for the opportunity to continue in that capacity. It's fun. What you have before you is this remote attestation, and I really look at this as being the little policy sibling of your remote notarization. It functionally, in terms of policy, does the same thing, recognizing that there are significant legal documents that require witnessing, sometimes one, sometimes two witnesses. The kind of isolation that we have seen in this COVID emergency that has really led to justification of moving forward now with the remote notarization really applies as well to remote attestation. It creates a process by which a witnessing of documents can be accomplished remotely through something that we created here. It's new to Oregon. We borrowed it from the E-Wills Act from the Uniform Law Commission. Thank you, Professor Gary. And that is the notion of electronic presence. And we established that at the beginning of the bill. I don't even call it a bill, it's a legislative concept. But this notion of electronic presence is a very useful thing. If you look at it, it's the relationship of two or more individuals in different locations communicating in real time to the same extent as if the individuals were physically present in the same location. If you can establish that, and if you can prove identity through some sort of electronic means, probably just by computer communication, then a document can be executed, can be witnessed remotely by a witness who is not in the physical presence, but is in the electronic presence. And then the bill creates this process by which the signature page of the person who signed the document is transmitted and printed so that the witness can sign it as well. And then we have the attestations that both the person signing the document and the witness execute that certify that they were in each other's electronic presence at the time the document was signed and witnessed. And then we give effect to that electronic witnessing to the same extent as in the physical presence witnessing. We did specifically exclude some documents from this. One, we exclude notarial acts because you're going to have another bill that expressly applies to notarial acts. We exclude the witnessing and execution of wills. Really, that was a matter that particularly the judges on the committee were so concerned about extending this to the execution of wills. That was just a policy call or maybe a political call. I did not want to be in front of the Judiciary Committee in a special session debating with our judge friends over the issue of the bill. So we exclude wills, recognizing that we also have Electronic Wills Act that could be coming forward in the not too distant future. And then we also exclude the witnessing of signatures on circulator petitions, mostly because we couldn't figure out what that meant. No, it wasn't practical to include those. Otherwise, anything that requires a witness, either one or two witnesses, is included. And I think I'll stop at that quick overview and ask Professor Gary if you want to add anything to it.
I think that covers it. The report kind of walks through the process that someone would go through to do a remote attestation. And I think there was on the work group concern about making it possible for people to get documents witnessed that need to be witnessed, balancing that with the concerns about any type of fraud. And I think the proposal does a good job of balancing those two things. One other thing I'll add about wills, as Lane said, we had to take wills out. And there were concerns about protecting wills and what this was going to look like if a will was attested this year and then not probated for another 10 or 15 years. So there were a number of issues. But some of the practitioners who were part of our work group have already been doing remote attestation of wills, and their intention is to rely on the harmless error doctrine, which we have in Oregon law, that says that if a component of a will can establish that a testator intended the document to be the will, that the court can then probate that document as a will and waive the precise compliance with the execution formalities. So what some lawyers are doing is having the testators sign and the witnesses sign remotely or through Windows or various sorts of things. And then one of the members of our work group says that she is then preparing an affidavit that she signs explaining exactly what happened and why, you know, the problem that the person is in a nursing facility that's locked down. And so we wanted the bill itself to make clear that although we exclude wills, we don't intend to suggest that harmless error could not be used, which is usually you don't put things in statutes in the negative that way. But we want to make it clear that harmless error could be used if it's necessary during something like this period. And then the same work group will turn to the Electronic Wills Act in the next little while. And I think that's going to be a better way to address the issue of wills. So that's the one thing I wanted to add.
And if I could add, and thank you, Susan, if I could add just a couple other things. I do want to call, well, first, we have a sunset clause in this. We applied the same sunset clause as is in the Notarial Acts, so that this would extend until next summer, with the idea being that really and truly, this COVID emergency is the impetus, but it's not the only reason why somebody may have difficulty in getting a witness to sign a document. So we think there's good policy justification for making this bill, this law permanent, assuming that they adopt it in the special session. So by extending the effective, the sunset date until June 30 or July 1, that gives the legislature next session the opportunity to make this permanent. The other thing I wanted to mention, and it's on page 4 of Susan's very, very good report on the bill. Originally, we had it drafted so that the concept listed all of the documents to which it applies, that is, documents that require witnessing. Instead, then, as you see, what we did was we said it applies to everything except, and so we listed out only the exceptions. But we think it's important that legislators know for policy reasons what documents are actually included in this, and so they are itemized on page 4 and on to the top of page 5 of the report. I'm guessing that probably the one that would be most heavily used would be an advanced directive. This would apply to execution of advanced directives. But you've got the full range of documents listed on there. The one that we will be sure to call out to the legislative committees, just so they understand the policy implication, is the I think it's the 6th bullet, request for medication under ORS 127-800 to 897. Just to be clear, that's the Oregon Death with Dignity law. The work group felt that the policy for making witnessing available to that was as good as any of the rest of the documents. We understand that there may still be some special concerns about death with dignity, and so we will be sure to highlight that as a policy choice if the legislature wanted to exclude that, or frankly, if you wanted to exclude that, that would just be a matter of pulling it out of that list on page 4 of the report and putting it into the concept as another exception. We took the other route to leave it in, but we did want to make sure that we identify all of those documents that are covered so that nobody would say that they were uninformed or surprised. Lorianne, did we miss anything?
No, I think that you guys have done a great job.
Well, thank you, Chair Shetterly and Professor Gary and Ms. Sills for all your work on this. I'm going to start with one question, and then I'm going to open it up to the rest of the group for additional questions. I was wondering why the definition of electronic presence does not require video. Am I reading this correctly, that you could do this over the phone?
I'll take a stab at that and then let Professor Gary. I think you could not because of the identification requirement. And I'm looking for it here. I've got the bill up on the screen. It looks like I'm looking at you. Yeah, it's subsection 4. The witness has to have evidence of the person's identity, and that would, I mean, I'm assuming, and help me out, but the intent of that is that would require some sort of video to be able to show that ID. You got a driver's license, passport. It's itemized in 4A, the kind of evidence that has to of identification that has to be shown as part of this process. Lori Ann, Susan?
I think that's right. And also, and I was trying to pull up, I had the report up and not the statute itself. I should have had that up. But the language, to the same extent as if the people were in the physical presence, is intended to bring video. You have to be able to see each other as well as hear each other as you would if you were standing right in the same room next to the person. So that's the intent of the, in this, I don't have the language, but to the same extent as if the two people were in the physical presence of each other.
I'm wondering if that's not worth saying more explicitly, either in the report or in the draft. I would hate somebody to try to do this via phone, particularly if it was someone that's personally known to them. Because if I read section 4 correctly, it says you have satisfactory evidence of the person's identity if the person is personally known, or if you can identify by means of one of the following forms of identification. So I could see a circumstance in which somebody calls someone up, you know, hello, it's Bob, and the person knows Bob's voice, knows who Bob is, feels like they can sign the thing that is then sent to them via email.
And I guess my question is, if it's sufficient to put it in the report, that's easy. We could put it in the statute. The reason it's not there is that we use the language from the Electronic Wills Act, and there is some benefit to having it be consistent with that. So I guess the question is the report, I think it's a good idea to put it in the report and make it explicit there, but does that feel like that's enough?
That feels right to me, but I'd throw it out to the rest of the group.
Well, and if I can add to that, I think another reason for a little bit of, for not putting it in the act is there was consideration in the work group about persons with disabilities. And, you know, do we need to make special accommodations in this bill or in this concept for them? And the sense was that leaving it general enough just to say, using the description that we have in the bill, the definition of electronic presence, that to the extent that there are adaptive technologies that may be something other than what we're using today that could satisfy the requirement of electronic presence, we didn't want to exclude that. So I think we were intentionally a little bit vague about that. And so to the extent that we need to clarify that, and it's a good question. I think I would do that in the report, but not in the bill.
Mm-hmm. That makes a lot of sense to me. I was just thinking about the fact of how comforting the presentation that we gave was in terms of electronic notarization and talking about how people could see one another and that there was a record of that. Whereas in this case, people are not going to have the same kind of record of the witnessing. And so there might be additional concern about whether or not there was actual eyes on to the extent that someone has the ability to see. Questions from other commissioners?
Just following up, I have the same concern that's already been discussed, and I'm not convinced that putting it in the report would be sufficient because obviously somebody who's just reading the statute would not go back and look at the report usually, just in the usual course of things. And also I'm wondering if you're talking about not having to have a video, are you saying that if, for instance, if someone was blind, then it would be fine to do it by telephone and the law would allow that? Because it seems like I'm not clear what it means to be communicating in real time to the same extent as if they were physically present. That language is not familiar to me without further explanation.
Well, if you wanted to do it, and you're the ultimate arbiters of what goes in, if you wanted to put it in black law, I think you would probably say in real time by sight and sound to the same extent. You could probably include by sight and sound in that A, and just make it very clear. That does, I think, to some extent limit what kind of adaptive technologies might be available, but frankly, we don't have any of those in mind at this point. So if you wanted to do it, I think you could do it there. And you're right, it's a risk if you put it in the report and just rely on that, although we hope people would look at the report to understand maybe better what electronic presence means. Lorianne, what do you think in terms of drafting?
In terms of drafting, I think that I like the idea of the by sight and sound if you're going to do anything, because that way you're not limiting it to video. And that's, what if our technology changes and needing to go in and change the statute based on some new technology that comes out. I think it would also be helpful to have that explained a little bit in more detail in the form language, because we did throw or include what electronic presence means down in the declaration form. And I think there, a layperson reading that would not necessarily know what that means. So I think sight and sound would help clarify.
That doesn't offend me if you want to do that as a commission.
Just raising my hand really quickly.
Of course.
So that makes sense to me too. And the one thing that is worth highlighting here is that this is going to expire, right? And so the hope is the legislature will re-up it, and during that period of time, there's the chance to rethink exactly the best way, to do this. So it's not like it's a permanent bill where it'd be a real chore to fix it later. So that maybe speaks in favor of sticking it in the language now and keeping it in the minds of the working group.
So in that case, then you would add it to the definition of electronic presence, and then, as Lorianne said, you would include it in the declarations that are to be signed by the person signing and the person witnessing. We included the definition of electronic presence there because we want to make sure that they know what they're certifying to when they say that they were in the electronic presence. And so if we're going to change the definition, we would just be sure to include that in the declaration document as well.
I have a question on that. If we add in the sight and sound, does that mean a blind person cannot serve in this function?
I don't think so, if it still says to the same extent as if the individuals were physically present.
Yeah, okay.
And, actually, we got an interesting report back. We had a concern about that. And Sandy or Susan, you may remember better than I, but somebody at one of our members, I checked with, I think I can't remember who it was, checked with the Blind Commission for the Blind. And I think what they got, pardon?
Was it Gretchen?
It was, I think it was
Yeah.
Gretchen. Maybe that's one of her clients, I don't know. And basically what she got back was that even among the cohort of people who are considered blind, really it's a fairly small percentage of those that truly are blind to the extent of actually not being able to see anything. And so to the extent you risk excluding, that's a very small group. And frankly, this doesn't create any problems for them that witnessing in the physical presence also doesn't have, I suppose, if they can't see a document being signed. So I think we were comfortable that we were creating at least a symmetry there between real physical presence and electronic presence for people who have that kind of disability.
Great. Other questions? Okay, well, do we need a motion on this, Sandy?
So the group, Lane, you have more history with the commission than I do, so I might require help here. I don't believe, I think the group as the commission is able to, I don't know if it requires a motion to edit it.
I always liked having the commission vote. I always considered the work groups to basically be presenting their work
Right.
to the commission. And especially in this case, if you want to amend it, then the motion to approve with that sight and sound amendment.
Okay.
I think Lorianne and Susan could then make the changes in the text.
So PK, I think we could do it if this group is of consensus that they all agree to add that particular amendment that's been discussed, it can be all in one motion. So to
That sounds
approve
good.
with the amended language.
Okay, then I will seek a motion to that effect. Someone wants to make it.
And real quick, PK, Lorianne and Susan, because you're the ones who'd be updating, I'll update the notes, but updating the actual statute. Do you both are on the same page about what that language is going to be?
I think so.
Yeah, this is Lorianne. So it would just be adding the communicating by sight and sound in real, or sorry, I don't have the text in front of me
Yeah,
now, but just adding in that sight and sound. Okay, yeah, that's fine.
Okay. Yeah, PK, I just want to make sure, but as long as those two folks are aware, I think we're in good shape.
Mm-hmm.
And can I ask one more question before we're voting on the entire document? The title page, it seems like it's missing some words in the title, perhaps? Proposal to blank.
Title page of what?
Of my
Of the report.
I'm so sorry.
Oh, I missed that too.
Oh dear.
Just a placeholder.
We can
Fill in
fix
the
that.
blank.
Yeah, that needs to be cleaned up. I had taken a report from a prior report, and
That's funny.
it's the proposal to. It should be remote. Oh yeah, I'll fix it.
Krista, thank you for bringing that up though. I missed
That's
it.
good.
Oh dear.
And sorry, so with respect to the change that's going to be made to the legislation, then are you guys going to need to add something to the report as well? Because usually you would just sort of, with respect to approval of the report, you would approve it, with the changes consistent with the changes we were talking about here.
Yeah, Susan, that's Jeff's question. The report will be updated.
Oh yeah.
Yeah,
Right.
of course.
That's a good point. And Jeff's history is correct that the motion should also be to approve the report as amended to go forward so that it is official legislative history of the commission.
Yeah.
Great, so I'm seeking a motion to approve the draft bill as amended and also to approve the report as amended.
So moved. This is Mark.
Second.
Second from John Kerry. Any further discussion on the motion? Okay, hearing none, we'll take a vote. All those in favor of the motion, say aye.
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 Any opposed? And do we have any abstentions? Okay, hearing none, the motion passes unanimously. Thank you, everyone. And thank you to the probate work group for all this excellent work on very short notice.
Thank you. Good to see you all.
Yeah. Thank you, Lane.
Okay, I'll
Thank
take
you, thank you, Lorianne. And PK, I will be, the probate modernization group is meeting next Thursday, so I will update them about the fact that about the motion, about the additions, and if they have any feedback for the commission, we can include that as or if they want to re-propose it for some reason, we can bring it back to the commission at our next meeting.
Great.
Andy, is that meeting on Thursday or Tuesday?
Oh, Tuesday. Sorry about that, Lorianne. You are 100% right. It's on Tuesday.
Thank you so much, Lorianne. So before we finish our brief meeting today, I just wanted to bring to the commissioner's attention that we are going to have a pretty serious issue to discuss at our meeting this summer, and that is the status of the Law Commission budget. Like pretty much everybody in the state, we are facing budget difficulties. Some of those are occasioned by the current state of the state budget. moving forward into the next biennium, but some of them are also occasioned by other things for the commission, to be frank. Some of those include in the transition from Willamette to the University of Oregon, our employees have come to the state employees, and we have some increase in amounts that are allocated for budget or for benefits. The name is escaping me right now. What is that we call that?
University of Oregon calls it OPE, other personnel expenses. It has its benefits as well as mostly it's also covering the entire university's obligations to the whole benefit system.
So mostly we're talking about PERS, but there are a few other things as well. Sandy and I had a meeting with the outgoing financial authority at U of O and her successor to talk about this. And we seem to agree that at least at this point, so long as the judicial department does not require us to return a substantial amount of money for this biennium, we are okay in the continuing the way that we are for the rest of this biennium. It is possible that the judicial department will ask us to return some money that has already been allocated. And the question there is how much. If it's a worst case scenario, we could be in the red this year. We don't expect that, but it's always possible. If that does happen, we probably won't know until the OJD budget is finalized in, I believe, February of next year. Is that right, Sandy?
Well, there's a couple factors, and I've been in touch with OJD's budget folks. It is possible they would take money back. That would be unprecedented for the commission, but it is possible, and I've modeled out what that would look like. If it's a 10% ask, we're okay. If it's a 20% ask, we're going to have some issues. So we just have to see there's no assurances yet. I know they're building those budget models, and I've been in communication. It looks like the best guess they can give us is if it happens, it will be in the 10% range. And we can handle that for the current fiscal year. Where we really run into issues is going into our requests for the 21 biennium. And that's what we'll discuss at the next meeting.
Right, and that may be an area that is going to need some, perhaps some extensive future planning. We are discussing things like, I don't think there's really much more that we can cut from the Oregon Law Commission budget. We really just,
Nothing.
Sandy and Debbie, who is our admin, who's half-time. That's about as lean as it gets. I am also working on some ideas for ways that we might be able to get funding from other sources that are not the state. We are statutorily allowed to do that, to get grants and other such things. And as part of that, I've asked Sandy and Debbie to work together to prepare some data about the value of the in-kind contributions that the commissioners and recruit members provide to the Law Commission. Having worked with other organizations that have volunteer lawyers, the value of that on a spreadsheet is really quite impressive when you consider everyone's billing rates in one room at the same time. And I really do believe that the Law Commission contributes a great deal to the state with a very little amount, bringing in a great deal of volunteer support that's worth a great deal. So we're hoping to marshal those resources to demonstrate the value of the commission. And, one of the things I find difficult about the commission's budget is that it is a very small drop in a very big bucket. And yet it is often our job, I think, to convince lawmakers that we should not be held to the same cuts as other folks who actually have more ability to cut. I think in our circumstance, if we cut much more, we don't exist. So we're not going to be able to resolve any of those issues today, but I did want you to know that that's going to be a pretty serious discussion next time, and I urge you to bring your friends, other commissioners, and your creative brains to the process. And I'd be happy to take any questions that you have right now.
And PK, really quick, my goal is to hold off as long as we can in meeting the next time. I really would like to do it this summer, but I would like to at least get some concrete numbers on whether we're going to need to return money to OJD, because we could have an issue where, just to be frank, if they would cut a significant amount, the only way to save enough money would be to cut staff salary. And if we got to that point, I think the commission should be making that decision rather than me.
Yeah. Sandy
So
and you and I have discussed that
Yes.
both for the prudent management of funds, I don't think any state employee should be in the business of choosing whether or not to cut their own salary.
Yeah.
So I think that the commissioners really need to weigh in on that to support you in the legitimacy of the decision.
So we're not there yet, but just an FYI, I'm going to try to hold off and schedule the meeting until I get concrete information from OJD. And we'll see a lot of that. There's a lot of factors that lead into that, but just want to make sure everyone was aware of that potential.
Makes sense. Any questions? I'm looking at Judge Bouchong and I just see the look of resigned determination that I'm sure you've heard this many times in other contexts by now, Judge.
I have, and I'm on the Chief Justice's budget strategy team where we're talking about these issues from the OJD perspective, and they're not pleasant conversations. And you talk about the mission of the commission, and in those contexts, I'm talking about the mission of the judicial branch of government and what services we deliver to our community that we're looking at cutting as well. So this is not pleasant, and it's not easy stuff. In terms of timing, my understanding is that if the legislature goes into special session by the end of June, which is expected, that we'll know the extent of the cut that we'll have to take as a judicial branch shortly after that. And because there's only a year left in the biennium, we'll have to move quickly. So there is a clawback of funds to the commission. We probably will know that fairly soon, within a month or so.
Yeah, thanks, Judge Bouchong. That is in line with what I've been hearing as well.
That's very helpful. Thank you. Any other questions about the budget? Okay, well, hearing none, let's go get on to enjoy this beautiful day. Sandy, have we covered everything you need to cover about future meeting planning?
Yeah, I don't want to, as Judge Bouchong said, until we get that concrete information, there's really not a point in scheduling the meeting yet. I think we're looking at a time within the month of July is my hope. And it's going to be a remote meeting, just the realities of the travel situation, at least through the summer. And we can discuss future meetings, whether it makes sense to meet. But it'll be a Zoom meeting just like this one. And once I have some more concrete information, I'll be sending out scheduling links to all of you.
Excellent. Anything else for the good of the order? Okay, hearing nothing. Enjoy the beautiful day. Stay well.
Thank you.
See you soon.
And Talitha and Debbie, stay on. Thank you, everybody. Hi, everyone. Hold on.
Hi.
Hi, Debbie, you're muted, and I may have done that to you, so let me, hold on. Hold on one second. I hear you, Talitha. Hi, Debbie. So good. So first off, you both were able to watch the hearing yesterday?
Yep. I didn't watch it.
Okay, no problem. It wasn't required by any means, but I think it went well. Hopefully, Debbie, did you enjoy the presentation?
I did. I was surprised that it was more informal than I thought. And I thought it was interesting.
You know, I think doing hearings by Zoom they're just going to feel informal. The reality,
Yes, probably
as you could probably tell, even the chair of that particular group is not a tech savvy individual.
Mm-hmm.
So it had some holes in it, but we did the best we could. And I felt bad because Lane didn't get to see it.
Lane, yeah.
But it's okay. He's a longtime veteran in the legislature and he understands.
Mm-hmm. It was great to see though. It was interesting.
Good. And Debbie, did you see were you there early enough to see the presentation from the court system? I'm just curious.
I saw a part of that too. Yeah, that was about the COVID.
Yeah, exactly.
Yeah.
And
That was
Talitha, I was
interesting.
thinking of just our work because, it's not what our work is about, but when you look, I've been looking through these statutes regarding courts because that's what we're working on. And part of the presentation was a circuit court judge out of Bend. Actually, I'm going to move, so just give me a sec. I'll stay on, but I'm just going to walk. Was showing what steps they're taking to try to redesign the courtrooms to be compliant with the guidance about COVID. And Debbie, I don't know if you saw that part of the conversation, but it's wild. I mean, they're literally building walls in courtrooms, and they're trying to figure out how they're going to keep juries apart. And it is, I would say, it's completely impossible. That's, no one wanted to say it out loud, but you can tell that there is no way the court system is going to be able to operate at, honestly, I don't even think 10% of its usual capacity. When you consider the hurdles that they have to go through, I mean, you imagine something like jury selection. Talitha, have you ever been on a jury in Lane County? Have you ever been called in Lane County?
Yeah.
So-
Well, I mean, I've gotten the letter.
Yeah.
I showed up once. The other time I didn't show up. I never
So-
heard.
So if you show up, as you know, and Debbie, if you have, there's 100
I
plus
have.
people there, and that's something they talked about. They can't do that.
Right.
So like they're not even going to be able to do voir dire. And part of the issue, especially for criminal cases where you have Sixth Amendment concerns about fair trial, I think anyone who is convicted of any type of crime with these restrictions would have a legitimate appeal based off whether or not all of the different mechanisms were in place to give them a fair trial. So
Yeah.
that was a part of the meeting, which was